What's up, everybody? We are back breaking down another day of the Karen Reed trial. And one of the witnesses today really leads me to believe that it actually is possible the Commonwealth does not call the lead officer in this case, Michael Proctor. We're going to break down why. We're going to run through some more of the forensic testimony and explain how I just can't fathom how long it takes to make some of these points that I think could be important points, but I don't know why it takes this long. We're going to answer your questions. We're going to look at flipped videos. We're going to look at inconsistencies in the evidence. We're going to look at potentially some of the best evidence the Commonwealth has produced to date, all in today's video. So let's get to it. Make sure you guys hit the like button and get ready for a ride. So much to get to today, and so little time, so it feels like, because we try to keep these to an hour, and it's about impossible to do that, but we're going to try. And we're starting with the same witness that was on the stand, basically piecing these pieces of the light back together, okay? And I am going to recap her testimony in about 30 seconds. But before I do, it's important to understand the entire point of this witness was to talk about all the different pieces of the taillight and all the different colors, and put them together and say they match each other and show how they go over the broken taillight from Karen Reed's vehicle. If there's a cover-up, if there's some other story, if the officers went in and broke the taillight, she has nothing to do with it. She was provided these pieces months later and just determined whether or not they fit together. They could have gotten through her expertise in 5 to 10 minutes. They could have gotten to how all the evidence was collected in all these different pieces in 5 to 10 minutes. And then they could have taken 10 minutes at the end to have her show what we're going to show you here, which is how all of these pieces fit together. Because that's her whole testimony. That's it. And the fact that it took hours to get to this, and again, I try to have a lot of grace for trial lawyers because I know it's hard. I know there's a lot to get through. I know you want to make sure you don't miss anything, but it's getting to be frustrating. And as we listen to juror interviews in other cases, and we see that they get frustrated when they're like, why are you doing this? Just get to the important stuff. And there's procedure and there's background and there's foundation you have to lay, but not like this. Not like this. So I'm just going to kind of skip through. I'm going to turn off the sound for a second and just skip through. We saw a million little pieces the other day. This is her putting them all together, and you can see how she taped them all together scientifically. And this is all the different angles of the light that she put back together, all eventually culminating into, I think it was like 3 larger pieces, exactly how they all fit together. Oh, yay. And the thing is, the defense isn't even going to argue with this stuff, right? The defense isn't going to argue that these pieces of the taillight don't fit together, because their theory of the case is the officers broke the taillight and planted it. So I don't think that you need to go into this excruciating detail. I think you prove it, you show it, you really make the defense lean on, okay, all these cops and all these witnesses, they're all in it. They're all in it together. Be like, you really believe that, members of the jury? Use your common sense. And if the jury believes it, they believe it. But going into this detail, to me, is, I'm not going to say wasting the jury's time because it's important, but it's definitely making it harder to understand than it needs to be. And they continue to reference items by their evidence number, 7-123. Is this what you're talking about? 7-182. Once you identify that those are the pieces of plastic for the taillight, just call them the pieces of plastic for the taillight. So you took the pieces of plastic for the taillight, right? Maybe in group 7- whatever. You put them all together and they get to the taillight. Use simple words. Make it easy. Because I hate when it's so complicated because I don't know if they're talking about the glass or the plastic half the time, because they're using evidentiary numbers. Once they confirm the numbers are the taillight, then they go back to using the numbers. And I don't get it. I don't get it. But let's listen to kind of the end of her testimony on direct on how all these pieces put together fit perfectly over this taillight that was removed from Karen Reed's car.
Can I have a moment?
Yes.
We're at 2150 on the screen, which has now been marked as exhibit 431.
I do.
And what are we looking at in 431?
So on the left is item 3-1, piece A, and then on the right is piece 1.
And this coming, if I got 2151. And this way, you recognize what's up on the screen, which has now been marked as exhibit 432.
I do.
What are we looking at in 432?
That is piece 1, on top of item 3-1 in mechanical fit.
Is that the mechanical fit that you were talking about earlier?
Yes.
Thank you. Ms. Cameron, you can take that down. Those items that you testified to earlier in item 3-1, the tail light housing, what, if any, conclusions regarding those items as far as physical match? What, if any, conclusions did you come to?
That item 3-1 and the pieces that make up piece 1 were at one time together as a larger unit.
Thank you very much. I have no further questions.
So what I would have done with this witness is the very first question I asked, actually not the very first question, after we laid her background and her experience, I would have said, what'd you do in this case? Well, I took all the pieces that were found in Fairview Road that were part of the tail light. I put them back together like a puzzle, fitted over the light to see if it would fit. Okay, let's break that down. And then you go into the stuff. So the jury knows from the jump, why is she here? What did she do? That's the stuff you got to get to early, especially if it's going to be kind of boring expert testimony, getting into the nitty gritty. You start her off so everybody knows exactly why she's here and what she's going to testify to. Then Yannetti starts crossing her. They go through the evidence numbers. They talk about how she didn't actually see any of the shirts. She didn't examine any of the shirts, sweatshirt, whatever. She doesn't know if any of this stuff was on the shirts, anything like that, which I think is important. And then they get to what she did and didn't test, and we're going to listen to just a couple minutes of her cross here.
Didn't look at 7-17 or 7-18. I only received the debris from.
Okay, well, yeah, that's my point. So with regard to
even that, I didn't receive 7-17 or 7-18. It's like, I didn't receive the shirts. The shirts. We all know what they are now, right? Let's just call them the shirts.
The orange t-shirt and the gray long sleeve shirt, those were given separate item numbers, and you examined what was the debris allegedly from those shirts, right? 7-18.18, correct?
Correct.
And that debris consisted of different categories, did it not?
There were different pieces of, there were different things inside of it, yes.
Yes, different categories of things, correct?
I'm sure.
All right, so one category was dirt and debris, correct?
Yes.
You did not test the dirt and debris, correct?
Correct.
Another category was, or were, I should say, several apparent hairs.
Yes.
And you did not test those hairs, correct?
Correct.
And another category, I believe you've already testified to, consisted of several pieces of red apparent plastic and one piece of clear apparent plastic that measured 1/8 of an inch by 1/16 of an inch. Is that accurate?
Okay, so there were several pieces of red apparent plastic and then one piece of clear apparent plastic measuring approximately 1/8 of an inch by 1/16 of an inch. Yes.
Okay. And I apologize for continually reminding you, but I'm just mindful that everybody needs to hear you. So to the best you can, if you can just keep your voice up, I'll try to do the same. So when those several pieces of apparent red plastic and one piece of apparent clear plastic came into your possession, those pieces were obviously not embedded in either shirt when you examined them, correct?
I don't know. I didn't examine the shirt.
Well, so to my question, the pieces that you saw were not embedded in a shirt when you examined them, correct?
Correct.
And again, that's because you never took possession of any shirt in this case, correct?
Correct.
The pieces were loose and they were not embedded in anything, correct?
The pieces were, well, I examined the debris from the shirt. I don't know what the person who packaged it did to collect that.
Okay. And so it goes without saying that you never saw those pieces on either the orange shirt or the gray long sleeve shirt, correct?
I did not.
And you obviously had no control over how the evidence was handled before it came into your possession, correct?
We have a chain of custody in the laboratory, but I did not follow the evidence as it went through the chain.
Okay. And we'll talk about the chain of custody in a minute. Before this evidence came into your possession, you did not witness who seized it, correct?
Correct.
You did not witness who handled it, correct?
Correct.
Before it came into your possession, you don't know who had access to that evidence, correct?
So all of our evidence is stored in locked facilities.
Right. But I guess let me modify that question. Before it came to your lab, you don't know who had access to that evidence, correct?
Correct.
You also don't know, before it came to your lab, whether the shirts in question were at all times kept separate from the red or clear plastic pieces of, pieces of plastic that were in the possession of certain members of the state police, correct?
Correct.
The chain of custody.
That's a good point. He's going to say at any time were they ever packaged together? How did this stuff, there's other ways that this stuff could have gotten on the shirt. I don't know how compelling that is. And we're going to hear testimony later about how the shirts were packed and how it was never with any of the plastic pieces. But of course, some people are going to say, it was planted and they did all this stuff. And they're going to always be able to say that for everything. But I'm trying to look at it to see, in the light most favorable to the Commonwealth, what are they proving? And that's really what we have to look at. And again, the frustration with some of this is not necessarily because I think this is good testimony. I think the state needed to do this. They needed to piece these pieces together. They laid the foundation. They were found at 34 Fairview. They put them back together and they said they were on Karen Reed's car. Okay, fine. Defense can get up and scream, cover up, and whatever they want, as much as they want to. That's fine. The Commonwealth has a job to do. Let's see if they can do it, right? And they did it today. And there are certain days where I feel like they do absolutely nothing. Today wasn't one of those days. I felt like they did at least move the ball forward a little bit.
Custody at the crime lab started with noting the state trooper who actually delivered the evidence to your lab, along with the date, correct?
Sorry, could you repeat the question?
Sure. The chain of custody at the crime lab starts with noting which state trooper delivered the evidence to your lab and the date that he or she delivered it, correct?
Or a crime scene responder, but the person who drops off the evidence to the laboratory, yes.
Okay. And in this case, which particular state trooper delivered the orange t-shirt and gray long sleeve shirt to your crime lab?
I don't know.
Well, which...
So she doesn't know, but eventually she looks and sees, guess who? Michael Proctor. And the defense continues to bring up Michael Proctor's name. More on that later. The lab didn't get this stuff till March. She doesn't know what happened from January to March. She was honest. I thought she did a good job. I know she was nervous. I think Lally made it more difficult than it had to be, but I think she did the best she could. She's obviously not an experienced witness, but at the end of the day, she accomplished her goal. She put them all back together and they fit Karen Reed's light. Fine. Okay, so this was something I was going to play, but again, there's so much I want to get to. I'm just going to kind of burn through it. I thought a very great part of this cross was he looks at the evidence bags, looks at the dates they were collected and given to her, and looks at who turned them in. So 5 days after the incident, there's a bunch of small pieces. On February 3rd, I think it's DeChico or whatever his name is, somebody not named Proctor, collected a bunch of pieces. There's a lot of small pieces. Why did he point out that there's a lot of small pieces? You'll find out. Then he goes to the next. Well, the next set was collected on February 8th, 5 days later. And it's kind of a big piece. And who found it? Proctor. So they want us to think, how did DeChico not find it? If it was a bigger piece than some of the smaller pieces he found, and it was all in the same area where Karen Reed allegedly hit John O'Keefe. Then he goes to the next one on February 11th, another bigger piece found by, you guessed it, Michael Proctor. Then on February 18th, now we're like 20 days after the incident, more big pieces found by, you guessed it, Michael Proctor. So there's date after date after date where Proctor kept finding pieces that eventually she used to put this light together. Now, is that reasonable? Is it not? That's going to be up to the jury. It's going to be up to the jury whether they think, yeah, it's reasonable that people keep going out there. I'll tell you what. I thought the cert witness, the guy that does the real in-depth searches, I didn't mention yesterday when I broke down his testimony that there were 3 people not in uniform that he didn't know who they were helping with the search. With all the connections and conflict of interest in this case, that's not great. But I loved his testimony about how precise they were, how they were shoulder to shoulder, how they had all the tools. Because I was thinking they would find everything, maybe not some specs, but were they going to miss chunks of red taillights in the snow that were this big? So I think part of that kind of hurt the Commonwealth because I would think those guys would have felt everything. Found everything. Sorry, those guys would have found everything. And now we know weeks and weeks were going by and Proctor kept finding more and more evidence. That is strange to me. It is strange. And I think we need Proctor to answer for that, how that happened, how he ended up there. Why did he keep going back? Did he know they didn't have enough? Because this lady didn't put it all back together until she had all the pieces, right? It's not like she put it all back together and then Proctor was like, oh crap, we're missing a 3-inch piece. I'm going to go back out there and see if I can find the 3-inch piece, right? That's not how it happened. So I found that interesting. And then on redirect, he just basically confirms that she never saw the clothes and there's not really much there. Then we get to the lady that handles trace evidence. Again, I felt like it was incredibly confusing. I couldn't tell if she was trying to prove that she proved pieces of the glass or the taillight were debris from the shirt. I know that basically when we got to her summary, it kind of basically told us the point of her testimony, but I thought she did fine, but I don't think she was overly effective for the Commonwealth in her testimony. But let's kind of listen to her summary in her report.
Right, there are several items that I'll just have to refer to my conclusion. If that's okay, my report.
Yes, you can go ahead and look at your notes.
So item 3-2 was found to have a physical match with 6 of the pieces of clear apparent glass from 7-12. But there was no physical match with the three other pieces from 7-12.
Based on that physical match that you determined, what, if any, conclusions can you come to with regard to those items that were physical?
Sure. So item 3-2 and the 6 pieces from 7-12 were at one time together as one unit. So then item 3-2 and all 9 pieces from item 7-12 were examined microscopically. However, there was no physical match found with the piece of clear glass from 7-14. Item 3-2 and all 9 pieces of clear apparent glass from 7-12 were examined microscopically, but no physical match was found with 2 of the pieces from the clear apparent glass from item 3-3.
So if I could make a suggestion, instead of saying the apparent glass from 3-3, I would say the glass from the bumper, the glass from the cocktail glass, the glass from this. Once you already identified where it was and where you got it from, you can start referring to it as the glass that was on the rear bumper of her car, the glass from the cocktail glass, like that, the glass on the ground. Start referring to it like that so the jury can follow. I mean, I'm listening to this, and one thing, just so you guys know, in full transparency, I try not to go back and watch this 2 or 3 times because I'm going to watch it a second time with you, obviously. But if I go back and watch it 2 or 3 times, I don't think that's a fair representation of how the jury views this case. And if we're able to pause and compare and do this and that, and that's great, and for breakdowns and figuring out what happened, but the jury's not able to do that. So from my perspective, it's got to make sense the first time. It's really got to make sense the first time.
Now, with reference to item 3-3 and item 7-14, what, if any, comparison examination were you able to do in reference to that?
Sure. So item 3 so two of the clear glass pieces from 3-3 were examined microscopically. No physical match was found with the piece of clear glass from item 7-14. One of the pieces that I had labeled as piece E from item 3-3 was found to be consistent in physical and instrumental properties with examined portions of the piece of clear glass from item 7-14. So accordingly, the examined portion of the piece of clear glass that I labeled as E from item 3-3 could have originated from the examined portion of the piece of clear glass from item 7-14 or from another source with the same characteristics.
Ms. Hanley, you used the term in there as far as instrumental properties. Can you explain to the jury what that term means and how it relates to your examination in this case?
So the instrumental properties, that's referring to the Grimm analysis that I did. So in comparing the refractive index from 3-3 versus 7-14. So
the clear apparent glass from item 3-2 that was recovered from the scene was a physical match for 6 pieces from 7-12, which were additional glass pieces found from the scene, correct?
I'm sorry, say that again?
Sure. So the drinking glass from item 3-2 was a physical match for 6 of the pieces from item 7-12, which was glass recovered from the scene, correct?
Correct.
And then the 2 of the pieces from item 3-3, or one of the pieces, excuse me, piece E from 3-3, which was from the bumper of the defendant's vehicle, was consistent with a piece of clear glass from 7-14, which was found on the ground, correct?
Correct.
Now, Ms. Hanley, in addition to that trace analysis that you performed with regards to the glass pieces, what, if any, other additional examination did you do with regards to items of debris?
Sure. So I also examined item 3-1 and 7-18.18.
Now, starting with item 7-18.18, what, if any, other description did you have as far as what that item was or where it came from?
So basically, here's what I got from her testimony. The glass matched the glass from the cocktail glass, but not the glass on the floor, on the ground, I guess, or the debris from the shirt, cocktail glass, but not the glass on Karen Reed's bumper. I think. I'm not 100% confident. And you guys may have seen it differently. Okay? You very well may have seen it differently. John said the scientist not being argumentative when returning questions looked great. In my opinion, the defense looked like too much. I thought the scientist seemed very credible, but I don't think it was the clearest presentation of evidence. That's kind of how I saw it. And then on cross, they start with chain of custody. They just basically saw if it matched up. They don't know. They didn't see the shirts again, stuff like that. I do think the defense cleared it up a little bit. And the reason I feel like I kind of know what this witness said is partially because of the defense questions on cross, which somebody said, Margaret said, if the jury is like me and they're waiting for the defense to make sense of what the Commonwealth's evidence is, that's not a good sign. I have felt myself doing that some as well, if I'm being honest. And mostly it's because of the numbers.
Condition.
So as you sit here, none of the items on the bumper.
By the way, we're on cross.
So the rest of the items were not used for physical match examination due to size and condition.
So as you sit here, none of the items on the bumper were deemed to match the cup, correct?
Correct.
All right. So you did end up analyzing one of the items on the bumper, item E as an echo, and you analyzed that against the single piece of glass found at the scene in 7-14, correct?
Correct.
And you used both, well, you used a variety, it sounds like, of analyses, including microscopy, UV light, the glass refractive index, GRIM process, correct?
That's correct.
You also used the FTIR, is that right? Infrared spectrometry?
That's incorrect.
Okay, you did not use FTIR in this analysis.
I did not.
Okay, but in the analysis that you did use, you found that there was a match between item E on the bumper and the single piece of glass in 714, correct?
They were found to be consistent. They were found to be consistent in physical and instrumental properties.
Okay, so importantly, you also compared the single piece of glass in our sort of visual column 4, 714, that single piece of glass to the cup. You found that it didn't match, correct?
Correct.
All right. So lastly, you tested the single piece of glass found in the fourth column, 714, against the 9 pieces of glass found in 712, A, B, C, D, E, F, I, K, and L, correct?
I did compare item 714 to item 3-2 and the 9 pieces in item 7-12.
So another way to put that would be you analyze column 4 against column 3 now, correct?
I examined them for a possible physical match.
And they did not match, correct?
There was no physical match to item 714.
Okay. You want to be a coach for this one?
Okay.
So one of the things Jackson tried to do was create a chart as his own kind of demonstrative and get the state's expert to use it, which is masterful when it works. It didn't work here. She kind of did the right thing. Like, I would have to take a lot of time to confirm all your stuff you put in here is correct. Not to say he put anything in there that wasn't correct, but you can't just trust what an attorney for the other side did. She did the right thing as a witness. It fell flat. But he did eventually move on. And what he's trying to do is, and frankly, the state should have done it. And this is her looking at what the defense created. And you can see there's 4 columns there. He tried to simplify it to make it easier for the jury to understand what you would think both sides would want. But it didn't work because she was not going to affirm his work. And that's not wrong of her, frankly. It's really not. June said, I watched today, and except for a few people, the situation is, for those who believe, no proof is necessary. For those who don't believe, no proof is possible. Mwah, I love it. I love it. And I agree with you. That's not how we're going to discuss it here. I'll just tell you, that's not how we're going to discuss it here. I'm looking at this. I'm trying to listen to what they say, judge credibility, and see if I believe what they're saying. And I believe what these witnesses are saying. I don't think it proves Karen Reed did it at this point with these witnesses, but I believe that what they got matched certain pieces, didn't match others, and lined up to be her taillight. So they did their job, in my opinion. The state has to put together the rest with the other witnesses. But I thought this was great because I heard a bunch of people saying, obviously it fits perfectly because they smashed it and all this stuff. There's going to be more to come later when we talk about that. There really is. Let's hear Jackson try to summarize her testimony.
We'll use a cheat sheet for a second. It is accurate to say that a cup.
So this question was a good one as well. The reports cannot go in evidence. There's a lot of hearsay and work product and all sorts of stuff in the reports that can't come in. So witnesses are not allowed to just like sit there and read their report on the stand, but they can reference it to refresh their recollection. Usually it's not referenced quite as much as it was these last two witnesses with all these numbers and little pieces and different evidence bags. The judge allowed them to, and that's appropriate, but it does sometimes go for a clunky presentation.
Was not found to match any items that were found on the bumper. That's correct. Correct?
That is correct.
Okay.
Sorry, I'm going to back
To
up so we can
confirm.
get that.
Fair enough. It is accurate to say, we'll use a cheat sheet for a second. It is accurate to say that the cup was not found to match any items that were found on the bumper. That's correct. Correct?
That is correct.
Okay. Also, it's fair to say that the piece recovered under 714, a single piece of glass recovered under 714, does not match either the cup, nor does that piece match any of the 9 pieces in 712. Correct?
And you can look at your notes if that's easier for you. We just want the right answer, Mr. Jackson, right?
Of course.
So take your time with your notes if that's easier for you.
So I'm sorry, can you just repeat the last question that you asked for?
The single piece of glass under 714 neither matches the cup, nor does it match any of the 9 pieces found in 712. In other words, it stands alone.
So that's correct. So
Okay.
714, there was no physical match between 714 and 3-2 or any of the pieces in 7-12.
Thank you, Scott. And then my final question is, the only piece of material, glass material, that was recovered from the bumper, item E, the only thing that any piece on that bumper matched was the single piece of glass found in 714. Correct?
So piece E from item 3-3 was the piece that I examined microscopically and instrumentally. It was found to be consistent in physical and instrumental properties with 7-14.
And that's the only piece of material on that bumper, in that section, in other words, in 3-3, that matched anything else in your analysis. A piece that was found singularly under 714, correct? The only one.
Yes, it was found to be consistent.
That's all I have. Thank you, Your Honor.
Okay. Sally?
Briefly, Your Honor.
All right. So, I mean, again, I don't know how much you gleaned from that. Not a whole lot from my perspective, honestly, except that the glass on the bumper didn't match the cocktail glass. Okay. But then we get to Yuri B, the trooper. Okay. The trooper that was step by step most of the case with Proctor, not everything, and not collecting all these different pieces of taillight with Proctor, but with Proctor. And when they went through his background, trooper since 2012, former Marine, high security clearance, investigator for the DA's office, I felt like it was a pretty great resume. And whenever you can present a witness like this with a pretty great resume for people that don't know him, right, from Adam like me or like the jury, or like a lot of you guys out there, right? Some of you, know a lot about what's going on and know a lot in the background of this case. But when we look at it and we see that he has this great resume, and Angela said, Peter, why do you play dumb? Okay. And I don't know what, we don't go after Angela in the chat. Fair question, right? I don't play dumb. I don't really know what you mean, but I'm going to assume you mean, why do I play dumb and pretend like Karen Reed could have done this? Okay. It's more logical that Karen Reed did this than all these other people are in a cover up. Okay. That's more logical. So I don't think that's playing dumb. Do I think that's what happened? I'm not so sure. Do I think the Commonwealth has proved it beyond a reasonable doubt? Absolutely not. Not even close. Not even close. The case ended today. There's no way. There's just no way. It needs to be a not guilty verdict if it ended today, no doubt. But I'm not playing dumb as I wait for the state to produce evidence. So many people are we're really arguing. And I was saying, man, this retrograde extrapolation, I don't put a lot of weight into it. Then we have some evidence today about how many drinks she had. And everybody swore she wasn't drunk. She only had 3 or 4 drinks. Everybody was telling me all this stuff. And that changed. And everything can change as evidence is produced. That's why we have to keep an open mind. That's why we have to watch the trial. It doesn't mean they're going to win. It absolutely doesn't mean the Commonwealth is going to win. I can't say that enough. It has not gone well so far. But I'm not playing dumb to wait for the evidence in a criminal case, which is what the law requires us to do. Unless you think just everybody plays dumb, that follows the law, which is the only way you could ever be a juror. So that's how I look at it. That's how I think we all should look at it. But I know that a lot of you guys know stuff outside the case. And Angela said, don't defend me. I just mean, I appreciate questions. And I appreciate people that see it one way and it's hard for them to see it another way. And I get that. And I'm not saying like they need to take it easy on you or anything. I'm just saying, don't come at her for saying she thinks I'm playing dumb by looking at it this way. I'm just want to explain how I look at it this way. Questionable evidence about the drinks. We're going to watch that together because we're, 30 minutes in and we haven't even gotten to the biggest and most important witness of the day. Okay. All right. So again, I think it's a good resume. Maybe this guy's part of the federal investigation. I have no idea, but I thought it was a pretty good resume to bring this guy before the jury and have him testify if he doesn't have all the same, dirt and stains on him that Trooper Proctor does. And the way they're going through the case with this guy definitely had me feeling and thinking Trooper Proctor's not testifying. I said it before when they kept mentioning who was with Proctor. Good was with Proctor. Yuri was with Proctor. This guy was with Proctor. That guy was with Proctor. Proctor wasn't there by himself, right? They've laid the foundation for that, in my opinion, to call a lot of other people so they don't have to call Proctor. And I can't stress this enough. I realize Proctor's got warts. I realize Proctor's got problems. But we already know about a bunch of them. We already know about him screwing up or misstating some quotes that prosecution witnesses have said. We already know about his connections to people and people's connections to his wife and coming to his house a couple days later. We already know all that. So to not call him, to either have the defense call him or the defense to argue they didn't call Proctor, to me, is a huge problem. A huge problem. And I don't see how you overcome that. They're not confident enough to call their own lead investigator. They tried to hide him from you because they saw everything we said and they saw everything now you've seen. If they don't trust Proctor, how can you? I just don't see how the Commonwealth overcomes it. And that's what's so hard for me. But honestly, as we go through Yuri's testimony, that's what it feels like. That's honestly what it feels like. Okay. So he was Proctor's supervisor. So I get why he could have some, reason to not have Proctor totally screw the pooch on this case. I get that. Proctor was scheduled to be on call that day. It wasn't scheduled ahead of time. It's just kind of something that happens. So there was no, grand plan. Proctor just happened to be the guy and he shows up and does it. Okay. According to Yuri. But I did want to play this little portion right here because the defense, obviously, they know the case a million times better than any of us. But the defense, throughout Yuri's entire testimony, wants to make darn sure that Yuri does not testify to something Proctor did or testify to something Proctor said. Because he can only testify to what he knows or he saw. Sure, if he was there, he can testify to what Proctor did if he saw it. But this was the first question that referenced Proctor and an immediate objection followed.
Those days are submitted in the beginning of the month. And then if it's in the beginning of December, for example, the on-call schedule for January is then compiled a month in advance, really.
So these are generated well in advance of whatever specific data trooper is on call, correct?
That's correct.
And as far as the detective unit within the North County District Attorney's Office, who, if anyone, is your supervisor?
Currently, my supervisor is Lieutenant Fanning, and the unit commander is Detective Lieutenant Brian Tully.
In that sort of pecking order, if you will, was that the way that it was set up in January of 2022 as well?
Yes, it was.
Now, on this morning of January 29th, 2022, at some point do you get a call in the morning, and from whom do you initially get a call?
I received a call approximately 6:44 in the morning or so from the H Troop headquarters, which is the field headquarters for the Metro Boston area, which also covers our county. And they advised me that there was a body in a snowbank in Canton. I asked for further details and advised them that I was not on call, but I would call the on-call trooper and let them know that there was a call out requesting their assistance. So that's what I did. I called Trooper Proctor and advised them to contact Canton Police.
And following that initial contact that you had from the H Troop and then your call to Trooper Proctor, what happened then?
Trooper Proctor began making phone calls, gathering information.
Sustained. Next question.
So Trooper Proctor began doing stuff, right? Objection, because Proctor has to testify to that. And sorry, I started the clip a little earlier than I wanted to, but Proctor has to testify to that. The defense isn't going to let this guy testify to stuff unless he saw it with his own eyes. Tracy said, without Proctor, are they missing the link of chain of custody? And Lally mentioned him testifying during his opening. Does that matter? I don't remember Lally saying specifically Proctor was going to testify. But yeah, I mean, I would think they're definitely missing chain of custody stuff if Proctor doesn't testify. And they can tell the jury, you didn't even hear from. But if they call him, right, then the Commonwealth gets to put on that evidence. Maybe it's a strategy game. Maybe it's a game of chicken. Who's going to call him? Does the Commonwealth wait until rebuttal to call him? I don't know. I've seen stuff like that happen in trial. I've done stuff like that in trial where I haven't called a witness, hoping the defense calls him. Then the defense doesn't call him and it doesn't end up mattering. So it's pretty interesting. Jessica said, if Proctor pleads the fifth and doesn't take the stand, can the defense still mention that in closing arguments? So I don't think there's a situation where he can plead the fifth to everything they want to ask him. I just don't see how, what'd you do? You went back and did this. Did you talk to these people? Who else was in the room? I mean, everything's not incriminating. So there's got to be certain things they can ask him about that aren't incriminating. All right. Next, we're going to jump to where he talks about, how he did the interviews with the McCabe's and Alberts, because it's an interesting inconsistency here.
Only take one vehicle, in addition to Trooper Proctor being able to
He and Proctor went together, by the way, so that's why he can testify to this stuff.
make phone calls and facilitate other logistics as necessary, allowed him that freedom to do so while I operated the vehicle in the dangerous snow conditions.
And the snow conditions that you were talking about as far as clearing out the driveway, the drive to the Canton Police Station, did those conditions persist throughout the day of the 29th?
Yes, they did.
And so you make your way over to the McCabe residence, again, without anything that was said. Who, if anyone, did you speak with at the McCabe residence?
We first spoke with Miss Jennifer McCabe. We then spoke with Mr. Matt McCabe, and then we spoke with Mr. Brian Albert.
And with reference to each of those conversations, were they done collectively or separately, or how were those interviews conducted?
Each interview was conducted separately. We first interviewed Miss Jennifer McCabe with request of Mr. McCabe to give us privacy. He proceeded upstairs. Once we were done with that interview, Mr. McCabe came downstairs, and Miss McCabe gave us.
I'm going to save that super chat until we get to the car section. There's some super chats I'm saving till the right time in the video. But listen to how he talks about how he did these interviews with McCabe and Albert.
The same courtesy. And once that interview was over, Mr. Brian Albert had arrived, and we interviewed him briefly.
Is that sort of the typical process of how at least your unit conducts interviews with respect to civilians?
Yes, with cooperating civilians, we typically advise them they were going to be, we schedule an interview. We proceed to their location of convenience and separate them and get their version of recollection of events that we are inquiring about.
Now, after you spoke with those three individuals, yourself and Trooper Proctor at the McCabe residence, where is it that you and Trooper Proctor went next?
So he said he interviewed them all individually. And I believe he said after Matt McCabe's interview is when Albert showed up, meaning after Jen McCabe's interview. I'm pretty sure, you guys can correct me if I'm wrong, but I'm pretty sure Jen McCabe said Albert was there and he was upstairs in her bedroom. So there's some inconsistencies about who all was there when they were interviewing them. Ashley said, are you starting to believe / see a cover-up? No, I don't really feel like that right now. Right now, I feel like horrible police investigation, not proving the case up, not being very convincing, not proving how the injuries correlate, or how the car caused these injuries, things like that. I just am seeing lots of holes, major important holes, that maybe could be patched, but I'm a long way from really believing, because I just don't feel like there's been any evidence about what happened inside the house to prove this. right? I mean, if we're gonna say they've got to prove something, they've got to prove it. And I don't think the defense has proven it yet, but I absolutely think they're providing a ton of reasonable doubt. A ton of reasonable doubt. Okay. They went to the hospital, saw O'Keefe there, cut the clothes off him. They bagged him immediately. They bagged them all in the same bag, it sounded like, which wasn't great. Then when they got to the station, they took it all out, kind of laid it out for it to dry. And this was potentially the worst part of this guy's testimony. I think there are some good parts that we're going to get to. This, to me, was the most frustrating part, the slimiest part of the case. If I was a defense attorney, this would have pissed me off. And they eventually get it sorted, but not until after he says things that are very frustrating that everybody in the courtroom should know this guy has no business saying.
You mentioned that you secured items and that you made observations of Mr. O'Keefe. Is that correct?
That's correct.
And can you describe for the jury, as far as Mr. O'Keefe's body, what were those observations that you?
Mr. O'Keefe's body was laying on his back. The observations I made were of bruising to the eyelids of his face. Based on my experience and having cases with head trauma, I can tell you that during subdural hematoma,
Yeah, I'll sustain the objection.
Brother, I appreciate your background and experience. I appreciate, what you do, helping people, protecting people, saving people, things like that. This is not your expertise. There ain't no way you can testify about hematoma and where blood pools and how the brain works and how the body works. There's just no way. And the fact that he even tried to, and this is the point about lawyers, right? And you can get frustrated with lawyers because they know the rules and they know what you're not supposed to get out of people and in front of the jury. And then they try to build it up, and we're going to listen to someone. They try to build his expertise because he's worked X amount of, cases that have dealt with head injuries. It's like, yeah, how many of them did you diagnose the problem with their head injury? None of them, because that's not your job. And nobody would ever want you or allow you to do that. And the fact that they kept trying to push it, somebody asked, where's the medical examiner? When's that testimony coming? Well, there better be. This guy better not have been what they were relying on, number one. And number two, if you have a medical expert, why are you trying to get this guy to testify to this? You don't need it. So why do it? This is the type of stuff that pisses me off when you try to get stuff out of witnesses. Because again, people believe cops. If you don't think that, go listen to some of the juror interviews that we've been breaking down. They believe cops generally. Now, I know there's a lot of evidence of conflict of interest and maybe some evidence of cover up, fine, but they believe cops. So if you can get a decorated Marine and cop to get up on the stand and say this stuff, a jury may believe it. But this guy has no more business than myself or E. Erickson in the chat or anybody else. Just get up there and give your medical opinion. With no training, no expertise, you would be qualified in no court of law in America to make this opinion. Yet here he is trying to force it in until the defense objects. It's very, very frustrating because this is easily avoidable. These accusations of sliminess from a lawyer are easily avoidable. And you guys know, I try to give people the benefit of the doubt. I try to be gracious in how trial lawyers handle cases. If sometimes it's fumbly, bumbly, or boring or whatever, I get it. It's hard. But you cannot do stuff like this. You got to make a decision as a lawyer, and you can't do stuff like this. There are all sorts of times you can slip in stuff that's inappropriate. You got to make the decision before you start trying cases that you're not going to do that. Because once you start doing it, I'll just tell you, there are plenty of opportunities to do it. And it's hard to stop once you start.
Build a foundation if you can, Mr. Riley.
Over the course of
Build a foundation if you can. So I guess that's kind of fair for the judge. Maybe he's got medical training. Maybe he's an EMT as well, whatever. But it's like a cop doesn't testify to medical diagnoses or causes of death. Come on.
your work with this unit in particular, if you know about how many homicide or let me step into it this way. As far as your work within this unit, as far as it's concerned, what, if any, jurisdiction does the State Police Detective Unit of the District Attorney's Office have with reference to not only homicide, but death investigations within Norfolk County?
By statute, Chapter 38, Section 4, each county, the District Attorney's Office is provided jurisdiction over all death investigations. As a result, the law enforcement entities that are assigned to that Norfolk or that district attorney perform the investigations. In Norfolk County, those individuals are members of the Massachusetts State Police assigned to the State Police Detective Unit within our office.
And so as far as death,
Congratulations. You know, you don't have jurisdiction over determining cause of death or medical diagnoses of people that you investigate what's going on with them, right? Like, how does this build a foundation for him to give a medical expert testimony?
investigations, what exactly or what type of investigations would that encompass?
Death investigations that we have jurisdiction over are all unattended deaths. Unattended death means that a physician, a doctor, is not overseeing the individual that passes. Those deaths would be suicides, homicides, overdose type deaths, natural deaths, accidental deaths, and so forth. Any type of death that is not overseen by a doctor at a medical facility or in a hospice type situation.
So as a result of your assignment to this unit and that sort of exclusivity of jurisdiction over unattended deaths within Norfolk County, if you know approximately how many death investigations have you been a part of over the course of your work with the State Police Detective?
Over the last 9 years, I would venture to say it's over 500 death investigations that I was a part of.
Okay. And again, that's great. And that's why he can testify on how to investigate a death. How many causes of death have you determined? Right? This is frustrating. It's really frustrating to me how lawyers are sitting there with a straight face. And again, maybe like whoever it was that said I was playing dumb, you know, maybe they're playing dumb, but you know that you can't do this.
Sergeant, over the course of your involvement within those investigations, if you know how many of those investigations involved some indication or some type of head trauma?
Scores of investigations that involve some sort of head trauma.
And through the course of your investigations, in those cases that have involved scores of head trauma, have you been privy to information as far as medical findings, autopsy reports, things of that nature in relation to those prior investigations?
Yes, sir, I have been.
Now, with regard to your observations of Mr. O'Keefe, with regard to his items, what if any observations did you make, and what if any? Well, let me start just with physical observations. What if any physical observations did you make of Mr. O'Keefe's face and body in general?
His face, I observed the swelling and the discoloration being produced through the blood pooling in the eyelids.
Yep. So just
My guy, like, is so frustrating. It's so frustrating that it's totally appropriate for him to say, you know, swollen eyes, injury to the back of the head, cut over the eye, cut on the nose, whatever. All that's totally fine, appropriate. He viewed that with his own eyes. Any man or woman that's looking at somebody can say that and describe it. That's a lay description. But then to say, from the blood pooling in his eyes, is not only even more appropriate this time because it's already been objected to and sustained, but he's continuing to try to force his medical opinion in front of this jury. I hate stuff like that. Like, just present the evidence, present the case. To me, I'll just say, to me, I'm sure the jury is not picking up on this or as annoyed about this as I am. But if they were, I'll just tell you, the rest of the testimony was a lot harder for me to get through for this guy. I was looking at him like a know-it-all. Like, okay, so you can give causes of death too. You can be the medical examiner too, and the investigator, and the conflict check, and the supervisor. You can just do it all. And it frustrated me with him, if I'm being honest, from the beginning. And this is why witnesses can build or hurt credibility throughout their testimony.
just your observation. So the swelling and discoloration.
Let's just try that last part.
I'll strike the remainder of what you've said.
I also observed a cut to his nostril and an eyelid, which was very small in size, which would have been produced by a...
Objection.
Yeah. So we'll leave it at that. Next question, Mr. Lally.
Like, dude, you don't know what it was produced by. I hate to say it, but that's like, it's just, I don't know. I've made my point.
Based on your training experience, what if any conclusions or what if any opinions that you have in regards to the swelling around the eyes?
Objection.
Yeah. I'll see you at sidebar here.
Hey, John.
Yes.
So, Sergeant Mechanic, with reference to your prior death investigations, have you had occasions to make observations of bodies that there was a later determination of some sort of subdural hemorrhage?
Objection.
I'll allow that. Have you made those observations? Have you been part of
Yeah, Hope, they've already heard that, right? So, I mean, I don't know. How much worse can it get? I guess probably pretty bad.
those investigations?
Yes, Your Honor. Yes.
And what you observed in regard to Mr. O'Keefe, was that consistent or inconsistent with what you had observed on those prior investigations?
Objection.
That I'll allow.
It was consistent.
The reason so I'm going to back it up so we can listen to that again because I was talking over it. But basically he says Have you had other investigations with similar injuries? And was O'Keefe, similar to those investigations and what you observed? The reason you can't anymore as a judge allow him to answer those questions, which would have otherwise been appropriate, I'll just tell you, if not for the attempted medical opinion of this officer, I think the judge can allow this stuff. What you've seen on other things that's similar to what we've seen here. The reason you can't let him ask it now is because he's tried to force that medical opinion based on this experience. That's not the experience he's trying to build the background for, the foundation for. You can't now let him bolster it. You've stricken it from the record. Move on to something else. But she lets him answer it and say, oh yeah, I have all this experience and this was just like all those other cases.
Of some sort of subdural hemorrhage?
Objection.
I'll allow that. Have you made those observations? Have you been part of those investigations?
Yes, Your Honor. Yes.
And what you observed in regard to Mr. O'Keefe, was that consistent or inconsistent with what you had observed on those prior investigations?
Objection.
That I'll allow.
It was consistent.
Now, in addition to the injuries that you observed to Mr. O'Keefe's face, what, if any, injuries did you observe to his extremities?
His extremities produced abrasions to his upper forearm and lower bicep area on his right arm.
And just as you use that term, I'm not asking for any sort of medical definition, but as far as you use that term abrasions, what do you understand that term?
I understand that term to be a injury sustained through blunt force trauma or friction to the epidermis of the skin where a crushing of the vascular system occurs and produces.
Come on, Yuri. Like, come on. The crushing of the veins of the upper epidermis or whatever he said. These let's listen to these big words he wants to throw out there to sound like a doctor when explaining what scratches on somebody's arm are.
Asking for any sort of medical definition, but as far as you use that term abrasions, what do you understand that term?
I understand that term to be a injury sustained through blunt force trauma or friction to the epidermis of the skin where a crushing of the vascular system occurs and produces that type of sign on the skin.
Let me just tell you from my perspective, okay? Just from my perspective. This may be helpful for a medical examiner to explain things like this. But as I've said before, and I've made this point a million times, the explanation of something that is so obvious and readily apparent to jurors with eyes and brains, we have pictures of the scratches on John O'Keefe's arms. We have pictures. So I don't need you to get technical in explaining what the scratches look like, because the jurors see the same exact scratches you saw at the hospital that were photographed. So, I mean, we have board certified radiologists explain what a disc herniation or a disc bulge and different things, a fractured vertebrae, and the jurors still want to look at the films themselves. I've said that a million times. But to explain what something as simple as a scratch is as an officer, it just feels like a reach. And I don't want to be disrespectful to this guy, so I feel like I might be going too far on him. Rebecca said, God bless you, Peter. You take your valuable time to explain this and leave your mind open. I couldn't roll with the punches as you have. I like you, have not made up a mind on this case. Thank you for what you do. So, Rebecca, I brought this up because I didn't know if you were going to throw some medical stuff out here, because I know you probably see a lot of stuff like this. And it's got to be like, imagine if this cop that was investigating the case came in and told you about brain bleed pooling in the eyes and explaining to you how all this stuff happened. It's like, thank you, sir. Was he hit by a car? Okay, thank you. I'll take it from here. It's not to be rude, but I'm a lawyer, right? When I do my taxes, I give it to my accountant. I don't tell him how to do it. If I was going to tell him how to do it, I'd do it myself. We've got to rely on professionals. That's the point. That's why we go to school and we learn and we practice this stuff. Ugh. Is there more from this part? Yeah, a little bit more.
And from your observation of the injuries to Mr. O'Keefe's arm, which arm was this again?
It was his right arm.
And as far as your observation of those injuries to his right arm, what, if any, as far as the consistency of those injuries, what, if anything, did you note or observe in reference to those?
Objection.
Consistency with what? With the
Let me rephrase this.
Yeah.
How were the abrasions that you're describing positioned in relation to each other?
each abrasion appeared to me to be linear and concentrated in a specific location on the arm. It didn't go any further north of a point and did not go any further south of a point. So it was concentrated in the elbow, a few inches below the elbow, a few inches above the elbow on the right arm.
So what does that prove, sir? Because again, I think this guy also wants to do an accident reconstruction here and explain to us how, because they don't go higher or lower on his arm, it must have been from the tail light, but like they covered a much larger surface area than a normal tail light would. Whatever. Okay, let's move on from this. He goes to Karen Reed's house. They end up interviewing Karen Reed, which we're going to get to what he said there. They went to seize her car and her phone. When he got there, the tail light was damaged. He also confirmed it was snowing and hard to see stuff. And, it's, again, when we get to the video, June's comment about, certain people say, oh, it's so clearly not broken, or, oh, it's so clearly broken. And everybody says that. I don't really know what I see in some of these videos with all of the, snow and stuff that's going on and the blizzards and the imperfect, not HD cameras and things like that. He talked about the tone and manner of the conversation with Karen Reed was kind of normal. They went easy on her because they know she had just suffered a serious loss. So we're about to get to the interview portion of him talking to Karen Reed. But before we get there, I'm going to answer a couple questions. And if you guys could hit the like button, if you haven't already. 13,000 people in the chat. Let's get this thing to 13,000 likes. Hit the like button. June said, Stephanie Lazarus, a detective, one of their own, said, I know how this stuff works. I have been doing this for a long time. It sounds like you're trying to pin something on me. Why would she say that? I don't know. Is there a jury instruction, Caitlin asked, that they can't take the omission of certain evidence testimony into account, i.e. lack of murder weapon in Murdaugh, because the state not calling the lead investigator would be sus to me? No, they can absolutely argue lack of a murder weapon or lack of a body as reasonable doubt. Lack of evidence can absolutely be. Now, there are certain things with witnesses you can say, certain things with witnesses you can't say. Some of it depends on the judge. But in most jurisdictions, if they're going to say Proctor throughout this whole case, and he was the lead investigator and you don't call him, that's a lack of evidence. That's a gap in the chain of custody. You can still argue the conflicts of interest and all the problems that came in with all these witnesses. And then you can connect and make inferences and arguments based on inferences from the evidence that came in. And they didn't call him because of all the evidence that came in. I think that's totally fair game and appropriate. I think some judges would agree with me. Some might not. Francis said, why did the trooper have to leave the stand while they played that Sallyport video? I don't understand what the big deal was with the cop shoveling snow. We're going to answer this when we get to that video. That's coming up here in a little bit. Let me see if there's anything. Ranger fan said, Peter, why have they not gone back to this video from opening statement? You can see she hit the car, it moves. So that is coming up. And he questions Yuri about that. June, it's possible they framed her, but it's not plausible. I asked about conversation with Stephanie Lazarus and LE, law enforcement. She said they do it. That is why people resonate with Karen. An accident, yes, but they overcharged her then. Melanie said, when the police go back to a scene, don't they have to document why they went and if they found more evidence to describe the circumstances? So yes, usually, but they can also say, I was just driving by, or I was going to see them and I just happened to see this there and then I collected it, and they document how they found it and collected it and usually take a picture of when they get there. Lo and behold, how did the judge allow the ring video when that was initiated by Proctor? So just because it was initiated by Proctor doesn't mean he's the only one that can testify to it if it's evidence that they collected. If another officer reviewed the evidence and looked at the chain of custody and how it got here and looked at the subpoena and that ring sent it to them, they're usually allowed to testify to that stuff as well. June asked, why Mr. O'Keefe instead of Officer O'Keefe? It's not quite the same thing as, doctor, but I think either would be appropriate. I don't think Mr. is disrespectful myself, but I'm also not an officer, so maybe I'm wrong about that. Okay, let's get to his interview with Karen Reed, which I thought was very revealing, and I did think it was a good chunk of evidence for the state. Again, I'm sure, people aren't going to like to hear that, but I thought this went well for them. Again, if you believe this guy and like this guy, he hasn't been my favorite witness, I'll just be honest with you. But if the jury's watching and they believe this guy and find him credible, this is going to be really, really important evidence.
Talk to you about this again at the end of the case, but for purposes of, as you hear the
She
test,
reads the instruction, these are the defendant's statements. If you think the defendant didn't say them, or if you think that she was coerced or forced to say them, or if you don't believe the officer, you don't have to believe the statements, kind of instruction to the jury before we talk about the defendant's out-of-court statements.
testimony, that's the lens that you have to sort of hear it through. All right, with that, Mr. Lally?
Thank you, Your Honor. Now, Sergeant Mechanic, when you began to speak to the defendant, prior to any sort of substantive conversation, what, if any, conversation did you have with her about the conversation you were going to have?
I just asked her to recount any events and the history between the actions that were taking place.
And how did she initially respond to that?
She stated that she's willing to answer our questions. She just doesn't want to go into too much detail about what transpired. And given the circumstances that she had just lived through, I understood and gave her that courtesy.
And as far as that interview or that conversation went,
She didn't want to go into the details. I gave her that courtesy, except that we had a conversation about some details I'm going to tell you right now.
can you describe that conversation or the contents of that conversation to the jury?
Absolutely. The conversation was normal tone of voice, like I am speaking to you right now. Ms. Reed responded in the same tone of voice, answered questions. The content of the conversation began with her saying that, as I stated, she doesn't want to go into too much detail, but she was willing to answer our questions. We asked what she had for plans, what she had for as far as activity the night before, leading up to Mr. O'Keefe being discovered. She stated that she was in a relationship with Mr. O'Keefe that morning, meaning the 28th of January. She got into a fight with Mr. O'Keefe over what the niece and nephew were being fed for breakfast, or what they had for breakfast. She went on to say that she met Mr. O'Keefe at...
They did not fight. Sorry, I'm screaming. They did not fight about another woman. They did not fight about John O'Keefe kissing someone. They fought about what they fed the kids. Are we supposed to take that as motive for murder? I certainly don't.
C.F. McCarthy's approximately 9 p.m. the night of the 28th of January, 2022. She stated that the gentlemen were drinking, consuming beers, Bud Lights, and she was drinking vodka soda. Prior to moving on to the bar at Waterfall, the defendant was asked where she parked her vehicle. She told me that she parked her vehicle on Washington Street across the street from C.F. McCarthy's, facing northbound. So the vehicle was on the side of Waterfall Bar and Grill. We went on through the conversation, the interview, to the Waterfall restaurant, at which point she was asked if she left C.F. McCarthy's with a beverage or container from that establishment, to which point she stated that she did not. She also confirmed that Mr. O'Keefe did not have any injuries on him when she interacted with him at C.F. McCarthy's or the Waterfall. She did not get into any verbal or physical altercations with anyone to have sustained those injuries. She stated that once at the Waterfall, they stayed for approximately an hour, hanging out with acquaintances. And then they left the Waterfall. She drove them to, after they were invited to a residence, she drove them to a location in Canton, where she dropped Mr. O'Keefe off. She was asked if she saw Mr. O'Keefe walk into the home at 34 Fairview, and she stated she did not. She stated that she made a 3-point turn after dropping him off and left. She was asked.
That's pretty much the defense is still their story today, right?
Whether or not Mr. O'Keefe, excuse me, let me back up. She was asked if she knew, how she found out about the damage to her vehicle, to which she stated, quote, "I don't know, it happened last night," end quote.
Now, at some point earlier in the interview, what, if any, indication did she give as to who Mr. O'Keefe was with when she arrived at C.F. McCarthy's, and sort of how long he had been with those respective people?
She indicated that Mr. O'Keefe was with Mr. Camarano, Kurt Roberts, at which point she was asked to provide contact information, meaning phone numbers for those individuals, at which time she picked up the phone on the right armrest of the couch, manipulated the device, entering a passcode, and provided that phone number to Trooper Proctor and I.
And at any point in time in the conversation or interview you had with her, what, if anything, did the defendant say in regards to why she had not gone into the residence at Fairview Road herself?
The defendant stated that she was having stomach issues and did not want to enter the residence.
Now, what, if anything, did she tell you about later on that morning of the 29th?
She stated that when she woke up, she began looking for Mr. O'Keefe. And when she found him in the snow, she began CPR on Mr. O'Keefe.
And what, if anything, did she say to you about any observations she made of Mr. O'Keefe later on that morning as far as any injuries to Mr. O'Keefe?
The defendant stated that while she was performing CPR, Mr. O'Keefe had sustained injuries and was bleeding from the nose and the mouth.
And if you recall, what, if anything, did she say about Mr. O'Keefe's eyes at that time?
The defendant stated that Mr. O'Keefe's eyes were swollen.
Is that both eyes? Is that correct?
That's correct.
Now, as the interview progressed, at some point, did you ask questions seeking further details?
Yes, I did.
And details about what specifically were you asking?
Once we got to the point in time where the defendant told me she did a 3-point turn,
But I thought you weren't going to ask her about details because she had been through a lot.
I asked her to walk through step by step of her operating the vehicle and exactly what she did. Prior to that, I asked her, excuse me, so she was asked to give a step-by-step recollection of how she, what she did in manipulating the vehicle and leaving the scene.
And at that point, was the interview terminated?
Yes, it was.
Now, once the interview concluded or was terminated, what, if anything, did you do with reference to Ms. Reed's phone and the defendant's vehicle?
Once the interview was terminated, I advised Ms. Reed that her phone.
So, and just so you know, like, don't talk to the cops. Obviously, we say that a million times every which way, because even when you do talk to the cops and try to, help yourself out or try to give them some details, eventually, whenever you stop, they're going to say she terminated the interview immediately and obviously make it seem like conscience of guilt and like she didn't want to talk to the cops and try to hold her a Fifth Amendment right to remain silent against her. It's just always how it is. They use whatever you say against you, and they use you not talking to you against you, you not talking to them against you. And whenever you stop talking to them, they use that against you.
Phone was going to be seized as evidence, and her vehicle was going to be seized as evidence as well.
And did you subsequently seize both of those items, sir?
Yes, we did.
And similar to the clothing of Mr. O'Keefe, as far as evidence was concerned, was that packaged and taped and transported back to the office in similar fashion?
The vehicle was transported via tow truck that was dispatched by Dighton PD on our request.
And we're going to take a look at that in a second. But lo and behold, they plan on seizing her car before seeing the car, nor did he mention anything about the car being involved before talking to her. I agree with you. He did say that. He did say we were going to go there to seize her phone and her car before they showed up and before they saw the taillight and before they talked to her, which I thought was very interesting. Very interesting. Christy, have I missed where they've proven he was hit by a car? Nah, unless I missed it too, I don't think you did. I don't think you did. Tracy said, regarding collecting Kara's car, is it odd they didn't produce a search warrant or even state what led them there? It's correct. I don't think they did. I can't remember that. So much going on. Why wasn't this Karen conversation recorded? Because it just seems like they don't record interviews, right? Yobi said the same thing. I guess they just don't record interviews. John, what's up, man? It's been a while. Hope you're well. Yobi, what stomach issue symptoms did Karen describe? She said she was having stomach issues. I don't know if that's going to do with the vomit. I don't know if they're trying to prove that she was drunk. I'm not really positive how all that fits together, to be honest. Okay. I'm going to show the car here for a second because I just want to, I'm going to turn the volume off. We're just going to kind of skip through it. So this is Karen's car. I mean, you can see how much snow is on there, right? Like the amount of snow at this point. Pulls it up. There was a lot made about, that tail light. Some people saying it's so obvious that it's not broken the way it's lit up. Other people saying it's so obvious that it's broken that it's lit up there. I just can't make a call on this case based off that. If I'm being honest, I can't make a call based on that. There's just too many unknowns. I want to see the part where, so this is when the tow truck is driving down the street, which once again, people are acting like they can tell for sure. And maybe some people have a better view than I feel like I have at this. But I can't make my decision based off of these videos on whether or not the taillight was broken. There were some questions in here I also wanted to get to. SS Live said, can the defense request a ring video to see if Proctor went to John O'Keefe's house to get the taillight pieces later? I don't think there is any video of that, or I think they would have gotten it. There's somebody else that asked a similar question. So I don't know that they said the taillight broke exactly like that, number one. Number two, with the state's expert on the stand, there was still a missing piece of the taillight. It wasn't complete. So my guess is with that information, I don't know if they came up with the theory before or after, but with that information, the defense is probably going to argue that's the only piece that broke at John O'Keefe's house. And when they went and broke the taillight at the Sallyport and planted the taillight pieces, they couldn't find that piece because it had already broken in John O'Keefe's driveway. That's my guess for what they're going to argue there. Okay, so then we get to this weird Sallyport video. Okay. And this, I don't even really know what to make about this. So we're going to discuss it as a family here on the channel. And I'm going to put Sue's comment up now. But the weird stuff that happens in this case, you never know what's coming next. So we're going to talk about how weird it is. Then we're going to talk about if it matters. This is very clearly to me a flipped video. And the first and most important indication is the car gets driven in and only one person gets out. So take a look at the door closest to us, but then also take a look at the door in the window on the far side of the car. It never opens. Nobody ever gets out. Somebody only gets out on this side, very clearly the driver's side. And that's not where the driver's side is in America. So the officer almost falls. They take pictures. They walk around the car. We're looking at the light. I don't know if people are going to try to convince me that that light is white or red or whatever it is. It's definitely on. I don't know if it's broken or not. But this seems like a flipped video. I have no idea why it would be flipped. I have no idea how it helps the Commonwealth if this video is flipped. Yes, the number 4, look at the writing on the car next to it. Yes. So I think it's mirrored. I just don't know why. How does this help the cover-up? How does this help the Commonwealth? I can't figure out why. Now, did they edit it? Are there parts skipped? And did they flip it just to muck it up some? And this is why wrong taillight, Peter, is what somebody's saying. I get it that that's the other taillight, but it doesn't look like it's broken to me. The taillight that we're seeing in this picture doesn't look broken. It's far away, but I just don't know. I don't know what this shows. So I guess somebody's saying the other side is hidden, but the camera's on this wall. So whether they flip it back, you still wouldn't be able to see the other side of the car from this camera. So I just don't get it, if I'm being honest. I don't know if this is important. I don't think this has any evidentiary value at this point. Karen Reed and her lawyers seem to be excited. They said it's on the wrong side. You can see that her lips being read that, saying that. I think the fact that it looks like it skips is more important. It looks like there's footage missing, and maybe it's missing of them cracking the taillight. I don't know. But anything like that's going to be a bigger deal in this case. And from my perspective, I don't like this weirdness. I don't know what it means. I don't know what it proves, but I don't like it. This is not the type of evidence we should have when we're convicting people of the most serious of crimes. So that's kind of my thoughts on that. And I'm sorry I don't have more because I don't know what the heck's going on with that. I really don't. And yes, on that tow truck, from there to here, ice melting off, yet we still have that glass on the bumper and we still have the one piece of hair on the back of the car. Seems tough to believe. Like, if that's their best evidence, that's tough. That's tough to believe. Okay, yeah, and the time jumps, people said, yeah, no, I absolutely agree with that. Okay, so then this was an interesting part of the testimony as well. Oh, it's back a little bit. Just as an example of how they are clearly distancing themselves from Proctor. And as I'm listening, I'm thinking, I don't think they're going to call Proctor. Are they really not going to call Proctor? That's what's going through my head so much of listening to today. And this is just another spot where I was like, wow, maybe they're not. We're overtime. I still got a big chunk I want to play too. So settle in. We probably have another 20 minutes at least to the video. Hit the like button if you like overtime and if you're going to stick around with us. Oops.
She give as to who Mr. O'Keefe was with when she arrived to see McCarthy's and sort of how long he had been with those respective people.
She indicated that Mr. O'Keefe was with Mr. Camarano, Kurt Roberts, at which point she was asked to provide contact information, meaning phone numbers for those individuals, at which time she picked up the phone on the right armrest of the couch, manipulated the device, entering a passcode, and provided that phone number to Trooper Proctor and I.
At any point in time in the conversation or interview you had with her, what, if anything, did the defendant say in regards to why she had not gone into the residence of Fairview Road herself?
The defendant stated that she was having stomach issues and did not want to enter the residence.
Shoot, I screwed this up. I put the wrong timestamp. Maybe it's 41. No, let's try 51. All right, whatever. I put the wrong timestamp down for this one. I'll try one more spot, maybe 631.
Okay, so leave it, move on from that. So you apply for search warrant, we'll move on from that.
So, sorry, my question is more geared toward as far as individual personnel within your unit. How is an investigation conducted as far as one trooper does everything, or is it collaborative?
Okay, here it is. Okay, so how is it done in your unit? Is it one trooper does everything? Is it only one trooper can testify to this stuff, or is it a team game?
Or how is that?
The reason I say we is because every investigation takes the entire unit typically to put an effort in to conduct interviews, analysis, and so forth. So it's a team effort each and every time. No investigation is a one-man show. That's why we call it a case officer, not a lead investigator, because the case officer organizes the individuals to assign different tasks and collect and organize the data that comes back from the third-party providers and from the interviews that are conducted.
As far as the interviews that are conducted through the course of this or any other investigation, is there ever an interview that's conducted just by one trooper or one person in any investigation that you've done with this unit?
It is no. We conduct interviews with two people, whether it's a trooper and a local detective, or two troopers assigned to our office, other state police agent unit within the agency.
Now, as far as the case officer, who was the case officer on this particular investigation?
The case officer in this investigation was Trooper Michael Proctor.
And Trooper Proctor worked under your supervision, is that correct?
That's correct.
So, as far as a search warrant for the ring video from One Meadows Avenue, who specifically sat down, put pen and paper, and wrote the search?
Trooper Proctor was the F unit.
And as far as from that search warrant, are you aware of the materials that were provided by Ring in response to that search warrant?
Objection.
I'm going to allow it.
I am aware of it.
And have you reviewed both material as well as the videos that were provided by Ring in response to that search?
I did.
Now, with reference to those.
So, what happened there? It's a team game. It's not all done by one guy. We always have multiple people at every interview. I supervised Proctor. Yeah, he put pen to paper, but I was there supervising. I'm the one who looks at stuff. I'm the one who supervises. And I know what he did to get that search warrant. I reviewed the stuff that came in, and that's how the Ring doorbell footage came in. And that's how I think they're going to call everybody but Proctor. I mean, that's the type of stuff. I mean, I've done this before with like a spine surgeon who also has a pain management doctor that's an anesthesiologist who does injections there, and the patient got injections and surgery. So we'll just, again, because I want to simplify it. I want to keep it tight. I don't want to call 10 doctors if I don't have to. So I will call just the spine surgeon who also does injections and knows how to do that and supervises the pain management doctor at his clinic. And he'll testify to the injections and the surgery because he supervises. He's done it before. He can testify to that stuff. So you can do it this way. But in this case, it just doesn't work. It just doesn't work. That's my opinion. Defense kept objecting. Judge let it in. They show the driveway and Karen driving in the driveway. They show her. Here's the part of the video where they show her leaving. And this is the part where the defense wants to say this is where she, cracked her taillight or damaged her car. And this is how Yuri describes it.
They did in the prior video 119.
Yes, you do.
That was something to address. Now, as far as the operator of that vehicle, are you able to observe who that operator is within that vehicle?
I observed the vehicle being operated. I cannot identify who that individual is, and then from that shot right there.
From at any point in the shot of the video that you observed, are we able to recognize the operator?
Not from that shot, no.
Now, with respect to the timing of this video, what time in the morning is this video?
This the timing of this video is approximately 5:07 a.m. when the defendant left the home through the garage via her vehicle.
This gentleman, if you could play through there. Now, from this particular pause portion of the video, Sergeant, what, if anything, of significance do you observe within the still shot of this portion of the video 153?
The portion of this video in the still shot presented identifies a missing, damaged rear right taillight, exposing the white light coming from the right side of that taillight.
And if you could, using the laser pointer, before you draw your attention to what you're talking about as far as that area of the defense vehicle. Now, earlier in that video, did you observe the defense vehicle coming close to or coming into contact with Mr. O'Keefe's vehicle?
Yes, I did.
Here's the question some people had earlier about this video from opening.
And as far as Mr. O'Keefe's vehicle, at least from this video, what, if any, damage did you observe to Mr. O'Keefe's vehicle?
No damage.
As far as the ground area around,
I certainly hope he's not saying no damage based on this ring video. Like, did he say he went and looked at it another day and there was no damage and whatever? But like, I can't see whether or not there's damage from this ring video.
Mr. O'Keefe's vehicle parked, specifically the rear of that vehicle, what, if any, red pieces or anything you observe on the ground around Mr. O'Keefe's vehicle?
Nothing was observed.
It's kind of a present.
All right. Then he IDs everyone in the bar videos. And this is where we're going to get to kind of a big chunk of video that, again, we are about to get to the part where they're going to go through all the drinks Karen Reed had. And I'm going to skip through some parts. But generally speaking, to me, we're going to watch it together. And I'm sure people are going to push back and explain to me how this is not her having a bunch of drinks. But I felt like this was a very good piece of evidence and part of testimony today that the Commonwealth is showing she had a lot of drinks. So when we look back at their retrograde extrapolation, I can believe it a little bit more after watching this video about how many drinks she has in a certain amount of time. And I just happen to know some of this from, trying DUI cases and doing some of this stuff. I'm not going to say I'm an expert. I'm not going to say I guarantee it. I'll just say, if in fact she had this many drinks, my guess is her BAC was pretty high. And you guys tell me if I'm wrong, and we're going to watch this together and see exactly what it all proves. But now we're about to get into the CF McCarthy and Waterfall bar videos. Karen shows up. And we're going to keep a close eye. We're going to listen to what Yuri says. Sleuthy said, Peter, why do you think the Commonwealth didn't show her drinking them? That's a great question. It's a great question. I guess we're going to assume she drank them if they kept filling them up, but it's a good question. I don't know why they didn't show her actually drinking them. I knew there was going to be pushback, Sleuthy. I just didn't know it was going to be that good this quick. All right, here we go. People say she 100% hit John's car. I think it's possible. I can't put 100% on just about anything in this case, if I'm being honest, which is not good for the Commonwealth.
Pause there. Now, from your review of this video, what, if anything, of significance do you observe in this part of the video?
This part of the video, I observed the defendant reaching over and retrieving a cylindrical tall cocktail glass from the bartender.
And again, given the understanding that the video is about 12 minutes off as far as the timestamp, the defendant entered about 8:51 p.m. and is receiving this drink about 8:58 p.m. Is that correct?
That's correct.
So drink one is at 8:58. And we're going to kind of go through and talk about when she hits drink 1, 2, 3, 4, and actually watch the bartender give it to her. Maybe I'll do this so you guys can see it all better, so I'm not covering up any of it. We don't know if it's vodka or soda in the glass, but one thing I thought was weird is he has the receipt and he started saying 2 Tito's, 1 beer. There was an objection, I think, because the beer was obviously John O'Keefe's, but there was Tito's on both receipts, but we didn't see how many Tito's she had. My guess is they're showing however many the state says she had, right? Or that'd be obvious that they could refute that, but it hasn't stopped them before. So, all right, drink 1 at 8:58, unless it's soda water in the glass, which hopefully the receipt would show a soda water.
If you could, just going to play that too. Now, Ms. Gilman, if you could go up to about 32 minutes even into the same video. Now I'm going to ask you to play that for the next 30 seconds or so, to about 32 minutes. And 30
So,
seconds.
Sleuthie, I will say one of the reasons they probably didn't show her drinking all of them, I would definitely make the argument in closing, if it exists, but that the judge doesn't want him to play, 2 hours of video showing her drinking and, no audio. But I would have asked Yuri, in the parts that we're not watching, did you watch them? Yes, I did. What was happening? Was she actually drinking these, or was she dumping them out? Was she giving them to somebody else? She was actually drinking all of these drinks before she got them refilled. I would have filled that gap with Yuri, especially if I had a consultant like you watching these videos and telling me, hey, why don't you show her drinking them?
And Sergeant, during that about 30 seconds or so, what, if anything, of significance did you observe the defendant to receive at that point?
A cylindrical cocktail glass.
And so that would be the second drink, is that correct?
That's correct.
And that's at approximately 9:15, is that correct?
That's correct.
First drink 8:58, second drink 9:15.
And Ms. Gilman, if you could go forward to about 37 minutes into the same video. If you could play that for about the next minute or so, about 38 minutes. So, Sergeant, again, from that about 1 minute portion from that video, what, if anything, of significance did you observe the defendant receive and do with any items?
She received the shot glass beverage and poured it into the tall cylindrical cocktail glass, and then Mr. John O'Keefe stirred it for her.
And so that would now be the third drink, is that correct?
That is correct.
And that's about 9:20 p.m., is that correct?
That's correct.
Ms. Gilman, if I could direct you to the fourth video, video number 4.
So that is the third drink at, did he say, I think he said 9:20.
And ask you to go about 50 seconds into 50 into this video. And I'm going to ask you to play this, Ms. Gilman, from 50 seconds to about 1:30.
Go ask mom. I don't remember specifically if that's how she described it. It may have been. I can't remember.
Thank you, Ms. Gilman. So, Sergeant, from this particular video, what, if anything, is significance did you observe the defendant receiving during this time frame?
She receives another shot glass beverage and then places that liquid into her tall cocktail glass and stacks the second shot glass into the first shot glass into the first tall cylindrical cocktail glass she had previously received and consumed.
So this would now be the fourth drink, is that correct?
That is correct.
And per the video, that's about 9:33 p.m., is that correct?
That is correct.
And Ms. Gilman, within the same video, if I could ask you to go to about 26 minutes and 30 seconds.
Everybody's saying that little girl will be falling down. This would tear her stomach up with, all of the issues that she has. I guess explain it to me. Explain it to me. Sleuthie, I think this is another good point. And I've been making this kind of the whole trial. Nobody else said she was drunk. Maybe it hadn't hit her yet, but I mean, it's 2 hours in. I would think it would have hit her. It certainly looks like what the Commonwealth is saying happened here. What else would be in shot glasses that she keeps dumping into that cup? I just, to me, if I'm thinking common sense, if I'm thinking, what happened here, I think it's plausible that these are drinks, right? I really do.
Ms. Gilman, if you could pause there for just a moment. I'm going to ask you to play this until about 27:40. Thank you, Ms. Gilman. During that period, Sergeant, what, if anything, of significance did you observe the defendant receive during that time frame?
She received a tall cylindrical cocktail glass.
And in
Was
addition,
it a refill of just the soda water, or was this another drink? They're going to assume it's another drink, obviously.
that, what, if anything else, did she receive from the bartender during that time?
A shot glass size beverage.
And what, if anything, did she do with the
That would seem like maybe it is soda water, and then she's dumping the shot when she's ready to. Maybe it's a double. I don't drink, so I don't really know how they come, but I'm sure you guys can. We know it's not a cucumber on her glass, but
shot glass in regard to the larger cylindrical glass?
It was placed inside the tall cylindrical cocktail glass.
So that would be drinks 5 and 6, is that correct?
That's correct.
And per the timestamp on the bar video, this is now about 9:57 p.m., is that correct?
Correct.
And Ms. Gilman, if I could direct you to video number 5.
so that's drink 5 and 6 by 9:57. So in 1 hour, 6 drinks. It does look like that. It does look like that. So Sarah's saying she didn't actually see the last 2. I feel like I did. I feel like I did see him as he's going through, to be honest. Because I tried to look closely. I really did. I tried to see if I could pick out any, but it definitely looks like the bartender is handing her something, and that it's happening each time they say it. I tried to look closely. If somebody told me it's not, and we slowed it down in the jury and zoomed in and did all that stuff, maybe, but this looks like a lot of drinks in a short period of time, and she's not done yet.
And if I could ask you to go to about 3 minutes in. And ask you to play that till about 3:30 or so. Thank you, Ms. Gilman. And if I could ask you to go to about 10 minutes and 30 seconds in. And I would ask you to play that for about a minute to about 11:30 or so. Thank you, Ms. Gilman. So, Sergeant, sort of round of shots during this portion of the video, is that correct?
That's
Yeah, sustained. You can ask it differently.
What, if anything, of significance did you observe the defendant
A round of shots.
or the group that she was with do in this portion of the video?
in this portion of the video. The two gentlemen to the right of the defendant consume a shot-size beverage.
And as far as the shot glass that the defendant received, what, if anything, do you observe her to do with that?
Objection.
I'll allow it. Or strike that. Just what did you observe, not what she had.
What did you observe the defendant to do during that portion?
Prior to the shots being taken, a shot glass was poured into the cylindrical tall glass.
And again, so that would be drink number 7 at that point?
That would be drink number 6.
And it's funny here because the officer's actually wrong. Lally's right if you're keeping count, but the officer goes back to 6. They kind of fumble through this. It wasn't, a great moment, but I thought it was interesting. And then Lally just kind of moved on because whether she had, 7 drinks or 8 drinks, the point is it's a lot of drinks in an hour and a half. Whoops.
And I'm sorry. So the previous portion was a cylindrical drink and then a shot glass that was 5 and 6. Is that correct?
Objection.
I think that was the testimony. Back it differently.
As far as that drink during that portion, was that drink number 6 or drink number 7?
Objection.
Yeah, in that form, I'll sustain it.
At this point in time in the video, after watching what you watched, how many drinks has the defendant consumed at this point?
At this point, she's consumed or is in possession of
Objection.
I'll allow it.
6 drinks.
And this is at approximately 10:29 p.m. Is that correct?
Yes, that's correct.
Ms. Gilman, if you could go to about 20 minutes and 30 seconds in. Actually, wait for the next.
So again, here's another good point. I don't drink, so I don't necessarily know. My wife basically drinks wine. So I guess this could be a thing too, where the receipts show Tito's, but it doesn't necessarily mean Tito's. But I would assume they would charge it right, and however many she ordered, they would put on there. I don't know. Hopefully we see that stuff. It was so weird that he was talking about what was on the receipts, but we didn't enter it into evidence and publish it to the jury.
So during that portion of the video, what, if anything, do you observe as to the drink the defendant has and then how full it is at that point?
She has a cylindrical tall cocktail glass in her hand.
And can you observe, or did you observe how full that glass was?
Drink number 6 is empty, or near the bottom, almost empty.
And Ms. Gilman, if I could.
So Sleuthy, while we didn't watch her drink it, that was like the best I guess they could do, that she drank it. But I agree with you. And I would have had him testify like, yeah, I watched the videos and you can see her drink all of these drinks.
Ask you to go to about 22 minutes and 40, I'm sorry, 22:40 or so within for the time frame also. Now, from this portion of the video, Sergeant, what, if anything, do you observe the defendant and Mr. O'Keefe doing in reference to CF McCarthy?
Once the defendant got drink number 7, the defendant and Mr. O'Keefe walk out of CF McCarthy's, the defendant holding the beverage, tall cylindrical glass in her hand.
Thanks. Now, may I approach?
Yes.
Ms. Gilman, you can take that down. I'm sorry. I'm showing you the 5-page document that you to review that without when we finish. These the transaction receipts or tabs that you received, you and Trooper Keith received from CF McCarthy on February 1st, 2022.
Yes, they are.
And with reference to those receipts or tabs, to whom, if anyone of significance to you, do those tabs pertain to?
The first one for 5280 was opened under the bar tab, Karen A. Reed.
And is there also a receipt from John O'Keefe?
Yes, it is. The transaction through the credit card, being a MasterCard for 5280, was paid by Mr. John J. O'Keefe.
And with reference to
Under the bar tab,
I missed how much hers was.
Karen A. Reed.
and is there also a receipt from John O'Keefe?
Yes, it is. The transaction through the credit card, being a MasterCard for 5280, was paid by Mr. John J. O'Keefe.
And with reference to the items listed within that particular receipt, what, if any, items of significance do you observe listed on the receipts?
Under Karen A. Reed's receipt, 1 Tito's, $10, 1 Tito's, $10, 1 Coors Light, $5.
Sustained.
So you don't want to make it look like she drank something that she didn't. That's why they're objecting to the Coors Light, and they end up not getting it in. But say 2 Tito's, and then later he asked if there was also Tito's on John O'Keefe's receipt, and they said yes. DG, this makes sense, right? So they want to act like, oh, this proves nobody messed with the light because it was on camera the whole time, but it actually wasn't because the camera flipped. Maybe, but it's just so obvious that it's flipped. I assume we're going to hear the defense point that out and cross eventually tomorrow if they get there, because we're not even done with direct yet. Probably all of the jury drinks alcoholic beverages, right? Rachel said, please find my long message in the chat. It's worth it. I will try. I'm struggling a little bit to keep up with the messages. If I'm being honest, I'm trying to keep up with them. Jen Morris, I don't know where it was at the scene, right? But a lot of people said there was no belt. And we saw the belt. Case isn't over yet. We'll have to wait. Rebecca said she's seen a fully functional adult with a BAC of greater than 500 in my profession. Oof. It's crazy. It's crazy. Okay, and then eventually we get to the waterfall, and that video and what he explains that he saw there. I think that's
Keith's receipt, there was Tito.
Objection.
Was up on the screen, which is now the mark that's 464.
I do.
And what do you recognize that to be?
That is the still shots presented to me and entered into the exhibit of Mr. O'Keefe walking out of the Waterfall Bar and Grill at 12:11 a.m. on the night of the early morning hours of January 29th, holding a cocktail glass.
Please write that in the second still on the second still. And again, do you recognize what's up on the screen, sir?
Yes, sir.
And if you could, you can laser pointer before you just direct your attention to where you observe Mr. O'Keefe and what, if anything, you observe Mr. O'Keefe holding as he's out of the waterfall.
Mr. O'Keefe is observed here. He's holding that shorter, fatter cocktail glass as he's walking out of the establishment.
And Mr. Yeoman, if I could have him there.
So yeah, I do think there's some leading questions, but I think the defense, like everybody else, just wants Lally to keep it moving. I don't think he's helping too much with the leading questions to make it a horrible setup, but there's definitely a lot of leading questions.
Yes, you're just the second one, please. And again, Sergeant, do you recognize what's up on the screen, which is now marked as exhibit 467?
Yes, I do.
And if you could, give the laser pointer direct your attention to what, anything, is significant to observe this step.
This is Mr. O'Keefe walking out of the Waterfall establishment, holding the cocktail glass in his right hand as he walks towards Washington Street.
Thanks. Mr. Yeoman, you can take that.
Okay, Tracy, I thought there was 2 tabs open, so that makes more sense. And that's why I couldn't hear how much her tab was. So $52 doesn't seem like 9 drinks, right? Plus his beers. And if there was only 2 Tito's on the tab, I don't know. I think there was 2 tabs. Maybe there were 2 tabs opened, but he paid all of it. $52 definitely doesn't seem like enough, right? I don't know.
Mr. Officer, we can have the lights. Thank you, sir. In mercy of that timestamp when you retrieved that video.
That video was confirmed to be accurate in time, as in real time. No discrepancy.
And Your Honor, with court's permission, if I could just publish 3 quick clips from what's been marked as Exhibits 53.
Okay.
Ms. Gilman, if I could ask from channel 3, the second video down. If I could ask you to go from the timestamp on the top of the screen to 10:54 in 25 seconds. Keep it play. I can ask you to pause right there. So, Sergeant, from that particular portion of the video, what, if anything, of significance did you observe further?
That portion of video depicts Mr. John O'Keefe walking in with the defendant gesturing to a group of people at the top of the screen, and then Mr. O'Keefe walking over and giving a hug to an individual that's part of the group.
So from the same channel 3, Ms. Gilman, if I could have from the 4th video down. If I could ask you to go 11:39 in 40 seconds.
Yeah, Tiana, I definitely think that this case could be stronger than it seems like it to all of us at this point because of the presentation, which I think is exactly what you're saying.
Pause there, thank you. And in about 5 to 10 seconds or so, I'm going to ask Ms. Gilman to pause it, and I'm just going to ask Sergeant to direct your attention to sort of the top right corner of the screen. Okay, so pause there. From that portion of the video, you observed the defendant in that portion of the video?
Yes, I did.
And what, if anything, did you observe her to be doing?
She retrieves a drink from the table and appears to consume it.
Now, as far as the drink and the tall cylindrical glass that you observed her walking out of C.F. McCarthy's with, what, if anything, do you observe from the glass that she's taking a sip of from this portion of the video, the waterfall?
It's a shorter, fatter style glass compared to the cylindrical tall style that she walked out of C.F. McCarthy's with.
Thank you, sir. Ms. Gilman, you can take that. And Mr. Officer, if we could have the lights. Thank you, sir.
So there's one big clip that I'm going to save for the very end. I want to hit some questions here real quick. Austin said, "Love your channel. Golf question. What's your handicap? Thanks for your comments." Right now it's about a 10, which is actually 10.7 right now is my index. I've gotten it all the way down to like an 8.2 is my best. I haven't been playing well for like a couple years, maybe basically 2 years, basically because of YouTube. It's taking up too much of my golf time, but my game is getting back in shape and I'm trending down. AK, how can evidence ever be taken seriously enough to convict when chain of custody is non-existent? It seems moot to me. Hard to make any tainted evidence seriously. Will Judge P make Proctor a hostile witness? Absolutely. If the defense calls him, he's going to be a hostile witness, no doubt. Kevin, Peter, how is it allowed for the judge not to allow the basis for an objection to be stated in court? I understand not allowing speaking objections, but why block basis? We talked about this a bunch in the beginning. It's very strange. I've never seen a judge do it quite like this before. I think it's going to make the appellate process even harder. But she wants to make sure there's no speaking objections in front of this jury. And these lawyers seem like maybe they would if they had the opportunity to. Julie, how were they able to pick up the SUV and phone without warrants? Is it because KR didn't say no? Maybe they asked and she just let them, or maybe they had warrants and they didn't tell us. I don't know. I don't know if they just left that part out or if she just consented, which you can do, obviously. Meg, it looked like Karen was talking to John's parents sitting behind her today. What do you make of that? I think those are her parents. John's parents, I think, are sitting to the left of Karen Reed. June, if I were her lawyer, I would ask him about cause and manner of death and every medical detail until he admits he doesn't have a clue. Judge allowed, based on experience, what would happen. Problem is, you would never want to do that because with a guy like this, he'll give any answer in the book. And if you ask the question, you open the door to get the answer. And if it really is bad and the jury believes him, then you're in trouble. Deets on the streets, we're up to witness 55. What's the most you've seen in a trial? Do you think the repetitiveness, redundancy will have a negative impact on the jury? I've definitely seen over 100 witnesses in a trial. This is nowhere near the most, but some of them are very clunky and hard to get through. Gringa, the state did not finish today. Basically, this is almost the end of direct. So there's going to be more direct in the AM. Maybe we'll start cross tomorrow. It's only a half day. Kathy Wright, should she have been read her rights if stuff was being seized? Yes, I would think so. I don't know if they did read her rights or not. They would have to have a search warrant to seize that stuff and a warrant for evidence in the case. For crying out loud, if you were the defense, Peter, would you call Proctor to hammer his behavior home or save the Commonwealth, not calling him as an argument for your closing? So I would have to know a few more things than I do know. I don't know the judge and how far she'd let me go in closing, but I'd like to do it that way. Because as good as I think I can hammer him in direct, he's definitely going to give them some points on cross. And he's going to say what they need him to say. Maybe the jury won't find him credible. Maybe they'll think he's a scumbag. Maybe it'll make him hate the Commonwealth even more. But I feel like they've already gotten so much of that bad evidence in about Proctor that why push it if you can also throw in and they don't even want you to hear from him. Gringa, will the jury be able to ask why Proctor wasn't called? No. Asia, I wonder if it's a camera pointed at one of those circle dome mirrors to give a wider view of the room. Safety mirrors in gas stations and stores. Wow, that's a great point too. In your opinion, if Commonwealth doesn't call Proctor, is it more beneficial for the defense to call him or not to call him and play it against them? So again, if I knew everything they had on Proctor, I'd be better equipped to answer this. But I think they have enough good stuff to hammer him on closing already. If they're going to call him, they better have more. They better have more details than we already have in evidence so far, is what I would say. But again, I would defer to them. They know a lot more about what he has to say than me. I don't know anything other than what's come out in this trial. Jessica, if the attorneys in Bev got word that he is taking the fifth, technically the judge can let both sides or tell both sides don't bother calling him, right? Isn't it up to her? So every jurisdiction is a little bit different on this, but I don't see how the defense would have nothing to ask him, that everything they would ask him would end up in him pleading the fifth. I would be surprised at that. Curious and curious, sir, does this case embarrass you? Law equals low standards. I disagree completely. I think they're putting on a pretty good defense, and I think we're upholding constitutional issues. I think that there are good and bad lawyers on every case. There are strong and weak cases. If I was looking at this case, what I've had so far, and I was the Commonwealth, I probably would not have brought it and tried it. But I think the defense lawyers are doing a good job. I think, the case is moving forward, and this is how justice is served in our country. If she says she didn't do it, here's her opportunity to fight against the Commonwealth, and they have their opportunity to prove the case beyond a reasonable doubt, which is their burden. Rebecca, how many drinks did she have before she went to the bar? 7 or 8, it seems like, at this point. Why not call the bartender to testify? I think that's a great point. Why not? Why aren't they calling the bartender to testify? Caitlin wants to know that too. What was put in the glass? What was she refilling? We heard the bartender from the Waterfall, right? Where's the bartender from CF McCarthy's? CF McCarthy's. Oh, Rachel said it's a Twitter message. Okay, good. I thought you were saying the chat. I was like, oof. SC said, Peter, it's one tab opened by Karen, closed by John. That's why they only mentioned one in his card. Wouldn't 7 Tito's be $70? I don't know how much that stuff cost, but I assumed it was more than $52. But of course, I could be wrong. Zom said, Peter, you're not only super serious today, you're super OT as well. Thanks so much for your time. Almost 10 p.m. there, right? It's late. Yes, it is late. It's actually past 10 p.m. now. But we're almost done. We're almost done. Reese's mom said, John's manipulating the straw. How do we know he's not drinking some or all of it? That's true. Squatch said, I've bartended for 20 years. Could it be she was only getting single or even half shots each time? It's more common than you think. I have no idea. I think the way he testified that she was taking a shot glass and pouring whatever was in it into the cylindrical cup or whatever he said. So he's not necessarily saying it's alcohol, but then Lally's following it up. So that's drink 1, that's drink 2, that's drink 3. And I wouldn't let them say that unless that evidence is, or that fact is an evidence. And then with the tab, it didn't really confirm that there's Tito's. I didn't think it was super clear, but it definitely seemed like she had a lot of drinks. Brooklyn said these are professional drinkers with high tolerance. And Liz A brings us to our last clip we're going to play today. At the end of the day, I'm going to move it down to normal speed so we can all read her lips when she comes back, or they come back from a sidebar after the jury is out, after she talks to her lawyer, and she turns around and looks at her parents who are sitting behind her. And this is what I thought she said as well, what Liz said. No Proctor. Ever. So I don't know if that means just the Commonwealth is not going to call Proctor. If for some reason they're not allowed to call Proctor, I'm not positive. But she very clearly, in my opinion, lips to her parents, and we're going to watch it one more time. Either no Proctor or not going to call Proctor ever is pretty clearly what she says at the end of the day today. Not going to call Proctor, not call Proctor, something like that ever. And then she looks right at the camera. She looks right at the camera in the courtroom streaming, which she knows is streaming, obviously. And then she looks back and talks more to her parents, and this time covers up her mouth. Maybe that was a different point. Oh, no, that was before when she said they have the wrong side. It's the right, not the left, when they were talking about the car. Then she covered up. So she knows where the camera is. And when she covers her mouth, you know, it's interesting because she knows the placement of these things. I think the cop hurt the Commonwealth. I found him to be smarmy, arrogant, and off-putting from the start. So you guys let me know. What did you think about that witness, Yuri, so far? I think there's a lot more to come. And Kat said, I love when you stream long. It's tough. It's tough because I'm so like fast-paced. I feel like I try to get so much in as I possibly can, but there was just so much to go through today. Hopefully you guys enjoyed it. Hopefully you did stick around. If you haven't hit the like button yet, there's over 15,000 people, which is crazy. Hit that like button. Make sure you subscribe. It's like the highest percentage of people watch these and don't subscribe. So make sure you subscribe, whatever side you're on. I'm interested in talking about it. I think there was some good stuff for the Commonwealth today. I think the drinking hurts Karen Reed's case a little bit, but I also thought there was some good stuff for the defense. They poked a lot of holes, showed a lot of problems with the investigation, showed how, like, what are we learning from this evidence? Is it important? Maybe there's going to be a bombshell with the flipped camera. I don't know. I can't wait for cross of Yuri. And then, of course, will they call Proctor is still an open question. I just can't fathom that they're not going to call him. But it does feel like it's starting to move in that direction. But got to call it just under 2 hours. Holy cow. Basically 2 videos in one day. But we only got one more day of court this week, and it's only a half day. So we have to get in everything we can about this case. So make sure you guys show up tomorrow. It's going to be in the afternoon, probably 2:30 p.m. if you can get there. We're going to be talking about what happens in court tomorrow. More of Yuri. I expect Yuri's going to take the whole day. Hopefully we get some cross in. But that's it. That's all I got. It's the final straw. Boone said, glad he listened to my message and started streaming on Twitter. I've been trying to get it up for a long time. John and I have had trouble getting it to work and stream on Twitter. But if you're on Twitter, hit that heart. Let me know you're on Twitter watching as well. Thank you for everybody watching over there. It's cool, man. Different stuff, new stuff happening. I love the growth. I love the push. We're pushing towards 400K subscribers on YouTube as well and 40K on Twitter. So give us a follow. Give us a subscribe, a like, all those things. If you guys enjoy the content and the conversation, you guys are the best. You make it so much better than it would be without you. Until next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.